you well this morning?
I am. Thank you very much, Deputy President. Did I say President earlier?
Yes, you did.
I don't think it's bad to promote you, but Deputy President.
Thank you. I'll afford you a few minutes to settle down, and please give me a signal when you are ready. Then we'll commence with the interview.
I am ready, Deputy President.
Thank you, Justice Madlanga.
Thank you.
Could we, first and foremost, establish your true identity? When the program for today was prepared, I observed that your initials were MRW. And when I queried that with the Secretariat, before I had sight of the papers, I was told that the source of that was your curriculum vitae.
The W is one of my given names, Deputy President, but I discarded it in my ID, but I guess out of what respect for my late father, we used to have a joke at home that he would give us names, the first name of a white person and that white person's surname. Like, fine, I have my Xhosa name, Mbuyiseli, but then he also gave me the names Russell Wilberforce. And the firstborn at home is Faith Rosalind. Then there's Windsor Winifred, Parksley Farewell, and so on. So we had that joke about first name and surname of white people.
Thank you, Justice Madlanga. I hope that the Office of the Chief Justice has taken note of that, and they should then convey that information to PESA. Thank you. Could you please take a few seconds, look around this table, and see if you know most, if not all, of the members of the commission here present?
I've seen the face. I don't really watch, but I will sometimes have glimpses of the interviews. I have seen some of the faces, but definitely I do know some of the people, of the commissioners, I'm sorry, and I know some of them very well, and I'm sure that some of them are going to do what one of my teachers used to caution against I'm sorry to waste your time, Deputy President, when we were debating at Maria Zell High School, and then when you came after your opponent, Sister Benedette would say, "Muni vragnium kennersne, muni vragnium," which means don't revenge or avenge yourself against your opponent. So I'm sure some of the commissioners here will want to do that. And may I request the two at the corner there, please not to do that.
Thank you, Justice Madlanga. Speaking for myself, I have to declare that I have known you for some, I think, 40 years.
It's a very long time.
And my first encounter with you was in the Mthatha Magistrates Court, where I appeared in a matter as a defense attorney. You were prosecuting, and the presiding magistrate, Mr. Houston Barnes, rebuked me for addressing you as my learned friend. And when I asked him why, his retort was that he is not learned. You mustn't address him as your learned friend.
I remember that, Deputy President.
First and foremost, I want to mention that you are the first of the 4 candidates nominated by the President of the Republic of South Africa for the position of the next Chief Justice of the Republic of South Africa in accordance with the dictates of the Constitution. We welcome you to this session of the JSC.
Thank you very much, Deputy President.
And we are tasked with the onerous duty and responsibility to interview you and the other candidates with a view to advising the President as to who we consider to be eminently suitable for the vacant position of the Chief Justice. Thank you.
Thank you.
You were born in 1962, and obviously by virtue of the position that you currently hold, you are a South African citizen.
Yes, I am.
You are married with 7 children.
Yes, Chair.
And you were appointed to as a Justice of the Constitutional Court on 15 April 2013.
Although I took up office with effect from the 1st of August 2013.
That's your official date of appointment?
Yeah, the official date of assumption of office.
Thank you. And you have been a member of that court for 8 years and 10 months now.
Yes, Chair. No, this is the 5th month, I think.
Okay.
Yes.
8 years, 5 months. Thank you. Section 176(1) of the Constitution provides that, and I quote, a constitutional court judge holds office for a non-renewable term of 12 years or until he or she attains the age of 70, whichever occurs first. Close quote. So you have some 3.5 years or so before you reach the end of your term at the Constitutional Court.
I will accept that. Must say, Kasach has raised an issue that I also used to raise, which is that maybe there is a possibility of saying I am entitled to the longer term, but I think, isn't there an amendment to the Constitution that refers to the term being determined by an Act of Parliament? Because I think in terms of the Act, there is then a reference to 12 and 15 years. The 12 years being in respect of judges, or judges appointed to the Constitutional Court having had the experience of at least 3 years, and then people without that experience being entitled to be at the Constitutional Court for 15 years. I might be mistaken, but that's my latest understanding. And it is on that basis then that there was the possible interpretation that because I was appointed directly from my practice as an advocate, my term could possibly be the 15 years. But on closer look, the possibility is that, and at a textual level, the possibility is that it should be the 12-year period, or 12-year term in my case, because I think the wording, in a sense, is neutral. A judge for 3 years. I had been a judge for 5 years before, and then I resigned around May of 2001. So short point, I guess, after that long explanation, short point, maybe I should just say, I'm willing to accept that it's 3 years, 6 months thereabout.
Thank you, Justice Madlanga. And when were you called to the bar, and for how long did you remain as a practicing advocate?
1991, after serving the then 6-month pupillage, I started in Tata at the bar in July of 1991. I was not long at all at the bar. I was called to act at the High Court in Tata in 1996, and then with effect from the 1st of September 1996 still, I was appointed permanently to that court.
Thank you. And apart from your practice, were you involved in any community work or took membership of any of the lawyers' organizations?
I've been a member of virtually all, leaving aside the organized bar, or so-called organized bar. I was first a member of the BLA, and then I switched over to NADEL, and I was a member of NADEL for the longest time. And I was also a member of Advocates for Transformation, and I even joined this august body on the ticket of Advocates for Transformation, but of course under the umbrella of the General Counsel of the Bar.
Thank you. Have you delivered any papers at various universities, both in South Africa and abroad? South Africa,
in South Africa, what I have done is to offer my services to lecture law students, and offering my services for free. I contacted, when I was on long leave in 2018, second half of 2018, I contacted Fort Hare University and Walter Sisulu University, and made an offer to both of them to go and lecture there, and both universities accepted, appointed me as a visiting professor, and I lectured at Walter Sisulu University, and thereafter went to Fort Hare. Yes, I have delivered papers at universities in the USA, but outside of universities, I have delivered papers, like, for example, maybe more what, it was a paper which I even converted to an article at Judges Seminar, one of these seminars for judicial education, and that one was, you would probably have seen the GCB comment touches on it. In fact, they deal with it quite extensively, and at paragraph 8.6, they even quote copiously from that. And the title of that was a feminist perspective in what, I forget my own title now, but it was on a feminist approach to the adjudicative process. That's what the substance was.
Thank you. Have you received any awards from lawyers' organizations or other bodies here or abroad?
No.
Before you were permanently appointed to the Constitutional Court, you had occasion to act there. When was that?
This was at the second half of 2000 and the first half of 2001. So it was a total of 4 terms, which in court terms would have amounted to a year.
And apart from the exponential increase in the workload of the Constitutional Court, have there been any major changes to speak of in relation to the practices and conventions that had been in place at the Concord 2000, 2001, and when you were permanently appointed as a member of that court in 2013?
Two that readily come to mind are, I do not remember, but I might be wrong. I do not remember that we did duty. I think the president, and this was before the Chief Justiceship was transferred from the Supreme Court of Appeal to the Constitutional Court. I think the president, President Shaskalson, basically did duty and would make the initial recommendations on what we should do with a new application. Do we set it down? Do we dismiss outright? Do we call for written submissions by way of directions? And all those sort of, and then we would come in at that stage. And as you have acted at the Constitutional Court, you know that is no longer how we handle new applications. Everybody, with the exception of the Chief Justice, does duty. Then another one that I remember readily is, I'm sorry, that we would go to conference to discuss how we saw a case immediately after argument. Again, as you are aware from your acting state at the Constitutional Court, you know that that is no longer a case, and that what we do now, the allocated scribe will, or has 7 days within which to prepare a post-hearing note, which is circulated to all colleagues, and colleagues must in turn comment on it within 7 days. Those are the two that I remember off the top of my head. There may well be others I've forgotten now, if there are.
Thank you. Justice Madlanga, I do not propose to take you through your judgment because I believe that your record speaks for itself, unless, of course, you would want to dispute that statement.
Let me take the credit, President. Thank you, Deputy President. Thank you.
Section 176(3) of the Constitution provides that the salaries, allowances, and benefits of judges may not be reduced. And there is a sentiment out there that if you do not raise the salary of judges incrementally, given the ravages of inflation, this is in effect tantamount to reducing their salaries in breach of Section 176(3), thereby in effect impinging on their independence. Do you have any thoughts on that topic that you can share with the Commission?
It is not a subject that I have applied my mind to. And I would imagine that as lawyers, my colleagues would have applied their minds thoroughly to it and come up with concrete arguments before I take a particular view. Outside of just the statement you have put to me, I would prefer to first have sight of and assimilate the arguments on which this view is premised. So I prefer rather not to go either that way or the other way, before I have actually seen concrete arguments. But I'm willing to accept that colleagues have a basis for saying so. Otherwise, I doubt that they would just make that point.
I want to put a proposition to you that if the salaries of judges are not competitive, the judiciary is unlikely to attract the best amongst the lawyers to the bench. I'm not suggesting that the salaries of judges should be, in parity with those that senior counsel command in private practice.
I will not argue against that at all. But now you've added the rider right at the end, because what you've cut across with that rider is exactly what I wanted to use to agree with the point that you were making. I wanted to say the fees that are charged now, based on what I hear, are quite high. I hear that counsel can make even 50,000 a day, 60,000 a day, 70,000 a day, and even more, 7,000, 5,000, and so on an hour. But you put in the rider that that's not what you are talking about.
Thank you. Justice Madlanga, I do not wish to take up much time with you, because all of the other members of the commission have questions to put to you, but there are topical issues that are already in the public domain, some of which I would like to put to you and then invite you to tell us what you think of them, if anything should be done about those. I'll give them to you all at the same time, if you could take a note of them. The Constitutional Court has been under attack lately from certain quarters about a host of things. One, the extraordinary long delays in rendering judgments, the quality of the judgments, and some of the criticism has not been charitable. Namely, in one instance, the person who was critiquing the judgment said that it is a prattle of nonsense. Some judgments are replete with incoherence, and reasoning is all over the place. The other one is that either the main judgment or dissent or both, which is viewed as being abrasive or combative, which is seen as reflecting adversely on the image of the court. Perhaps I should just pause there to afford you the opportunity to respond.
I have actually prepared quite a long note on the delays. It would take a very long time for me to go through it, and that would probably test the patience of commissioners. But maybe let me just try to summarize what I see or or understand to be the cause for delays. Let me just quickly go to some statistics that I have here, Chair. May the commissioners please bear with me.
Please take your time,
Yes.
Justice Madlanga.
Thank you. I'll rattle them off the top of my head. I can't find them now. But for a long time, from about 2009, and 2009 is a signpost because that is a time when the working procedures of the Constitutional Court were last revised. Around that time, and even beyond, up to 2013, new applications averaged around 100, just over 100 in total. And then came, with effect from the 23rd of August 2013, a constitutional amendment which afforded the Constitutional Court what we loosely call general jurisdiction, the effect of which was that the Constitutional Court no longer adjudicates only constitutional matters. As you know, Chair, it now adjudicates even matters involving arguable points of law of general public importance. It was to be expected that there would be a sudden deluge of applications. Indeed, there was an increase in 2013 already, that is the year of the amendment. But that year, the increase was modest, and it is understood we were was left still to run. And then so I think the figure there was still in the hundreds, but upper hundreds. And then in 2014, the figure shot up well over 200. And then since 2015 to today, new applications have been averaging well over 300. Last year, they were 394. So in no time, we may get more than 400 new applications. To somebody sitting here, that may sound like a very small figure. Based on how the Constitutional Court works, that is actually a very large figure. And this is a function of the Constitution. How? Because how the Constitution is structured, or how it provides, the Constitutional Court, unlike the Supreme Court of Appeal, for example, cannot decide cases in panels. At the Supreme Court of Appeal, 2 judges can dispose of an application for leave to appeal without the colleagues even having sight of that application. At the Constitutional Court, because the court is constitutionally defined to be 11 justices subject to a quorum of 8, all 11 justices, or at least 8, must participate in each and every decision that the Constitutional Court takes. That means each and every one of us must bring her or his mind to bear to each one of the 393 applications that we received last year. That is the one thing. And then added to that is how we used to work, or how we used to do new applications. As you know from your time there, Chair, we used to have the duty week system. In terms of that duty week system, 2 judges would be on duty for a whole week. Those 2 judges would be the first port of call for new applications. If 4 applications come in during that week, they split them in the middle, or if an odd number comes in, the judge who took the first matter will get more. So we'll get the 5th matter as a 3rd matter for her or him. A disadvantage in this, in fact, at least 2 disadvantages. The first was that the weeks were hardly ever the same. In one week, there could, and in fact, there were far more applications than the following week. Let me be anecdotal and just give an example of one very unfortunate colleague, Justice Mhlantla. In 1 week, I forget who she was paired with on both weeks. I'm going to touch on the 2nd week. She and her duty partner got something like 22 or so applications in 1 week. Then other colleagues came in a few weeks, and then when after a few weeks she was back on duty again, she got another 20-something applications. Again, I've forgotten who her duty colleague was. Now, the problem with the duty system was that there would be a deluge of applications all coming in at the same time that had the effect of bogging you down, slowing you down in being able to deal with them expeditiously. That then had a knock-on effect on everything else that you do. In the same way that I've explained, about the decisions that we have to take, and my focus, of course, in this context being on new applications with judgments as well. I earlier mentioned the post-hearing note that I said you are aware of. A scribing chamber will circulate a post-hearing note on a judgment. The post-hearing note, commissioners, if I must explain, being just a summary by the allocated scribe of the approach that the scribe proposes to take in a particular manner, giving reasons why. And as I said, colleagues must comment on that. So you have this deluge of, and then down the line also, after 14 days from the deadline for comments, that colleague then must circulate a draft judgment. So you have this deluge of applications. The time has not stopped for you to have to comment on other colleagues' post-hearing notes. And remember, there are 11 of us. You must comment on 11 post-hearing notes that are in circulation. And once drafts come in, you must draft judgments. You must comment on 11, or 10, by the way, because you have your own. You must comment on 10 draft judgments. And as I try to emphasize, you have this deluge of applications that has come in at the same time. That had a very negative impact on how we work. Did we throw our hands up in a Pilatian manner like Pontius Pilate did? No, we did not. Last year, in the second half of last year, a decision was taken by conference on what we should do about this. Maybe I should just add that the knock-on effect of all this was that in the end, judgments would be delayed because come the deadlines, because there are set deadlines in the working procedures, 7 days for a post-hearing note, 14 or 7 for comments on the post-hearing note, 14 days for the first draft, and then 14 days for the next draft, and it's always 7 days, 7 days for comments on whatever. Now, the effect of that would be, come the deadline, colleagues would ask for extensions, and that delayed the process. But as I say, we did not throw our hands up in the air. In the second half of last year, a decision was taken by conference, I'm sorry, or that we should revise our working procedures. I was in the fortunate position of being one of the colleagues, the 2 colleagues chosen to perform that task. And the other justice that I was paired with was acting Justice Daya Pillay. We have produced a document, and I must acknowledge the assistance that we got from our law clerks. In particular, I want to single out Sarah Goldman, who did a wonderful job on that. On what we came up with, we have not circulated the full document to colleagues. When Justice Pillay left a couple of weeks back, we were still in the process of finalizing the rest of the document. I hope to have it circulated maybe during the course of February. But here's something that I consider quite important, which we did. One of the suggestions that we have put forward in the working documents is to do away with the duty week system. And because we identified the duty week system to be at the center of our problems, we took our suggestion, which was suggesting to colleagues that we do away with the duty week system. We took it away from the rest of the document. We presented it to colleagues, and fortunately, colleagues accepted it, and we implemented it immediately. It took effect on 5 December 2021. How does this cycle system work? We list all the names of the judges on there, with the exception of the acting Chief Justice. And the first case that comes in is taken by the judge who is first on the list, and then the second one by the second judge, and so on until you get to the end. The effect of that is, 1, there is even distribution of new applications, and 2, there isn't the problem of a deluge of applications all coming in at the same time, with the result of bogging you down. From the 5th of December to this day, I have received only 3 applications under the cycle system. One was now a couple of weeks now in January. I have already finalized and circulated decisions on the first 2 that I received. That is a function of the very fact that you do not have that sudden deluge that just pins you down, as it were. Now, this is not just about me. It is not just about me. I have spoken to a few of my colleagues and asked them how they find the cycle system. They too say that it is quite a pleasure. It is a great improvement on how we are able today to finalize new applications.
Justice Madlanga.
Yes.
I have to interrupt you there. The long and short of what you have just told the members of the commission is that you have identified some of the factors which are contributing, to the excessive delays that are experienced at the Constitutional Court, and that you are in the process of putting measures in place to address or deal with those challenges.
Yes. And yeah, now it's freeing up a lot of time. We are going to be able to even attend much quicker to everything else that we have to. The comments on post-hearing notes, comments on draft judgments, and so on. So much that in the proposals, which I would, to the extent that there was something about a vision here, I would put that in as my vision. Of course, with my partner, Judge Dayapile. One proposal.
Deal with that.
Because your question was about judgments, let me perhaps just zoom in on that now.
Yes.
So with the freeing up of time, I believe that we are going to be able to deliver judgments much quicker. I have a firm belief on that. The proposal has something concrete, but we are yet to put it to colleagues. And that proposal is that we must deliver judgments. People will probably, commissioners and other people listening will perhaps still feel that it's a long time. But we are putting down a proposal of 5 or 6 months for the delivery of judgments. We have done a comparison, and this compares quite favorably with what happens in other foreign jurisdictions. I would say the United Kingdom is an outlier because there they deliver judgments within a few weeks after argument. That's an outlier. Some of the other comparators are, in fact, most of them are, that is those that we looked at. I do not know about others, but those that we looked at, most of them are 6 months, and I'm talking about apex courts of those other jurisdictions. So 5 or 6 months, looking at what pertains internationally, I do not think would be that bad, as long as we do the best that we can to stick to that. And I believe that with the time having been freed up, it should be attainable.
Thank you, Justice Madlanga. Section 174(2) of the Constitution provides that the need for the judiciary to reflect broadly the racial and gender composition of South Africa must be considered when judicial officers are appointed. And yet, looking at the composition of the Constitutional Court, there's no white judge, be it male or female, and the last appointment of a white judge to the Constitutional Court was in 2009. So for 12 years, no white person has been appointed to the Constitutional Court, despite the fact that during that period there has been about 7 vacancies. Would you want to weigh in?
I would throw that one back at this august body, Mr. Chair. But more seriously, I think there is a point to be made about all of us as South Africans being made to feel that we all belong. So I do not, speaking for myself, think that it would, maybe let me not put this in the negative. I think it would send a good signal if there could be an appointment from that sector of our community. But let me say this, Section 1742 is not so categorical as to say, this is it. If there is X percentage of white people, then that is the representation that they should get at the various levels of the court. If there is that percentage of another grouping, even including outside of racial groupings, other possible groupings as well, LGBTQ+, and so on. That is not what, the Constitution is not categorical in the sense that you just must have that kind of composition, but it is giving an indication that there must be an attempt at attaining that. And as I say, I think it would send a positive image to try as much as possible to go in that sort of direction. But as I say, not to the extent of saying that it just has to be done. I would not go that far.
Justice Madlanga, we have now reached a stage where I must afford you half an hour to tell the members of this commission and the nation at large how you see the role of the Chief Justice in a constitutional democracy, and also share with us your vision of a functional, efficient, accountable, and independent judiciary in South Africa. Thank you.
Thank you, Chair. I must say you've removed a chunk from what I had on here as part of my vision, which was the idea of dealing with what I consider to be the largest elephant in the room, which is what pertains at the Constitutional Court itself. So I was going to share there what I see as my vision. Well, I believe that I have already done so. What I also would have emphasized in the context of what I've already debated in the context of new applications, what I would have emphasized was the fact that with the delays on which I think we now have a solution, perhaps there could quite easily have been an impression out there that maybe we do not work hard enough. I had intended to dispel any such possible perception. I just wanted, at a factual level, to make the point that we actually do work hard, in fact, very hard. And I even wanted, anecdotally, to share with the commissioners that I was working on Christmas Day. I delivered a judgment on the 31st of December, 2021. Those are the sort of times when people are having fun, when people are with their families sharing time, resting. And again, I want to emphasize, this is not just about me. Even if I will not know for a fact when my colleagues were working around this time, but I know they were actually working. And I say this because around the festive season, there was a point when my inbox, my email inbox, had well over 600 unopened emails from all my colleagues. So the point I would have made would be that whatever the reasons, and I've tried to zoom in on them, and I have shared my vision on addressing them, and we have immediately effected part of it. May I also, just again focusing on the Constitutional Court, say that one aspect that I feel conduces to a lot of injustice and which needs to be addressed is the problem of seating even numbers. I touched earlier on the fact that the Constitution provides that the quorum is a minimum of 8 judges. I remember when I acted at the Constitutional Court asking one of the colleagues, I forget who it was, why it is that the Constitution chose an even number for the quorum. And the colleague said it was felt that 9 was too high and that 7 was too low. I'm not sure that that is a good enough reason. Because the point is, in fact, when I asked the question, I was not aware that the Constitutional Court had ever been evenly split. Not at that time. But the commissioners sitting here, I'm sure you are aware that in recent times, there have been quite a few cases in which we have been evenly tied. That is a very unfortunate outcome for litigants. Because when you appeal, it is not just appealing for the sake of appeal, you are actually exercising a constitutional right under the rubric of a fair hearing, fair trial. You are also entitled to the right of appeal. And now, here's the injustice. Once we are evenly tied, the effect of that is that the judgment appealed against stands. So it's as good as if you never appealed at all. So it must be clear to everybody listening here that that is an injustice. I want to approach the minister, if appointed, I want to approach the minister to move that there be a constitutional amendment and that we do away with the quorum of 8 and that we decide, it may be 7, it may be 9. I'm not that much concerned what it should be, but preferably 9, because 7, if we are a court of 11 justices, yeah, maybe 7 would indeed be too low. But I'm quite comfortable with 9. But the even number just does not make sense for me. Then what adds to the problem is that now we ourselves, outside of that minimum of 8 in terms of the Constitution, we ourselves do sit 10. And sitting 10, we have had 5-5 splits. Maybe that too would have to be addressed, but unlike the quorum, maybe it does not necessarily need a constitutional amendment. It's something that could be dealt with even in an ordinary act of parliament. Or we ourselves could internally find a practical way of dealing with this. For example, in the late 90s, I also acted at the Supreme Court of Appeal. I remember preparing very hard for my very first hearing at the Supreme Court of Appeal. And then 2 or so days before the hearing, Chief Justice Ismail Mohammed approached me and said his deputy had taken ill and was therefore not available to sit, and he asked me not to sit. So that we were a panel of 5, so that they could then sit a panel of 3. Reluctantly, I had to say yes to that. So because exactly, or exactly because of the fact that at the SCA they have devised a practical way where there is no statutory or even constitutional bar or problem as such, I think we too at a practical level could just do that. But I guess, the issue would be who do you take out and why out of 10 colleagues. But maybe we could just find a practical way, maybe rotating or whatever else. But perhaps the best would be an amendment to, or rather, a statutory amendment at whatever level. It might be an act of parliament, or it might even be a constitution, the constitution. And I would, of course, with regard to the quorum, which requires constitutional amendment, request those members of parliament who sit here to support the move and also push for that constitutional amendment. Then also there is the question of administrative functions for a Chief Justice. I must confess, Chair, that sitting outside of the leadership of the court, I cannot claim to be aware of the exact functions of, that is, administrative functions of the Chief Justice, outside of those that are constitutional or even statutory, for example, in terms of the Judicial Service Commission Act. Outside of those, I cannot claim to know what they are. But if appointed, I propose immediately to engage with other heads of court and the Secretary General of the department responsible for court administration, which is called the Office of the Chief Justice. The idea will be to establish the extent of the Chief Justice's involvement in administrative functions. In striking a balance between administrative and judicial functions, we must pay particular attention to the fact that, first and foremost, a Chief Justice is a judge, a jurist. As a judge and constitutionally ordained head of the judiciary, I believe that a Chief Justice must lead the judiciary from the front in terms of the creation of the country's worthy and lasting jurisprudence. Depending on the nature of administrative functions that the Chief Justice currently performs, one may have to look closely at them and see which ones, if any, one may have to be relieved of. Of course, there are those functions that are prescribed by the Constitution and other laws like the Judicial Service Commission Act and the Superior Courts Act. The Chief Justice must and has no choice perform those. I should not be misunderstood. I am not saying that outside of those, the Chief Justice must perform no other administrative functions. What I am saying is that a Chief Justice must not be a super secretary general or a super director general. The Office of the Chief Justice, which is the department responsible for the administration of the judiciary, is headed by a Secretary General, and my understanding is that Mayor Sijo Singh has been performing a sterling job in that regard. And I understand that for the past 3 or 4 years, the OCJ has had clean audits. All the more reason that a Chief Justice should not be a super Secretary General. But this does not mean that the Chief Justice must be in the dark as to what is happening with regard to administration. There should be those necessary interactions between the Chief Justice and the Secretary General. In the main, a Chief Justice must be a trendsetter in the creation of our jurisprudence. That, for me, is the core function of a Chief Justice. That does not equate to the Chief Justice being in the dark. I've just made the point. A balance must be struck. Moving on, for a while now, I have heard the idea that some court rules are no longer suited to today's circumstances. If appointed, I will sit down and, with a thorough tooth comb, identify those rules and bring them to the attention of the Rules Board. Of course, this is not something that I can and will do alone. Because I'm talking about rules in general, there are the uniform rules, there are even practice directives and so on. So I would definitely have to involve other heads of courts in that process. I think of the example of rules, both in the magistrates' courts and superior courts, that require parties to have an address for service of all process on them within a specified limited radius from the seat of the court. Take the example of a poor, self-representing person who lives in, and I'm addressing your province, Judge President Tlalezi. Take the example of a poor, self-representing person, and I'm taking the Northern Cape because it has the vastest land mass area in South Africa. At least that's my belief. Maybe Advocate Madonsela's province who compares fairly, but I think the Northern Cape has the most vast land area. Take the example of a poor, self-representing person who lives in Springbok in the Northern Cape and knows nobody in Kimberley, where the seat of the High Court is. Bear in mind that the distance between Springbok and Kimberley is some 780 kilometers. Where and how will that poor person find an address within the stipulated radius? Also take Constitutional Court Rule 1.3 that requires the filing of 25 copies of all documents, which include records that may be quite lengthy and very expensive to produce. What makes matters worse is that Rule 20, Sub-Rule 2H, says the lodging of electronic copies of documents does not relieve the party concerned from the obligation to lodge 25 hard copies. I've just taken out 2, but when one sits down, one would be able to come up with many. But the point I want to highlight here is that rules of this nature are at odds with the right of access to court. But I must say that perhaps this, and I'll qualify it shortly, this may be ameliorated to an extent by the rollout countrywide of the court online system. The court online system was introduced by the heads of court at the instance of Chief Justice Mogoeng after he had observed its beneficial use elsewhere in the world. Heads of court decided to first run a pilot phase, and Gauteng was chosen for that purpose. This system comprises two components, which are what is called customer relationship management dynamics, and the short that they use for that, and I assure commissioners it has nothing to do with the president of the country. They call it the CRM dynamics. The first component concerns what under the present system would be an interface with the registrar's offices, the lodgement of papers, giving of case numbers, and so on. CRM now makes it possible for all this to be done online. Now, the second component, case lines, is at the other end of the process. That is what actually happens in court, the documents that the judges will have before them, and then what will also go into case lines as the hearing itself unfolds. And my understanding is that the pilot implementation of this at Gauteng took place under circumstances that were not the model circumstances that one would have wanted it to the system to unfold. And this is how this happened. Microsoft was engaged to set up the system, and Microsoft said, with case lines that you can buy off the shelf, it's a system that's out there readily available. But the CRM dynamics has to be custom made, developed for a particular client. And that has just been finalized on my understanding and will again be run as part of the pilot project in Gauteng. But case lines, or rather, yes, case lines was implemented immediately after a license had been purchased. Now, the problems I was alluding to were, because the two systems interface, you receive the documents, everything on CRM dynamics, then it has to interface with case lines. There had to be, because you don't have the CRM dynamics, there had to be a lot of scanning and so on at huge expense for purposes of uploading everything onto case lines. But Gauteng managed to get on top of that, and they got it running. But now that CRM dynamics is ready, the two will interface, and again the two will still run as a pilot in Gauteng, but for a short time now, and there will be a rollout countrywide. But my understanding is that this will be a phased project, not all courts at the same time. Phased because you need the support system to see whether the project is running smoothly. So an incoming Chief Justice will have to be on top of things, see how the process is running, make sure, or try to make sure as far as possible, that the phased implementation is not delayed more than it should. I said there was something I was going to come back to shortly. So when Court Online is fully operational, the idea is to be paperless. Of course, this will create problems of its own. A large number of the South African population either does not have access to computers or is computer illiterate. So the question remains as to how that section of the population will be serviced. My understanding is that there will be kiosks at high courts to assist people who cannot upload documents onto the system. There will also be a call center that will assist people over the phone. But commissioners will immediately see that if you are computer illiterate, there is nothing that somebody at the other end of a telephone, there's nothing they can do to help you. That takes us back to the self-representing Springbok litigant who must travel to Kimberley to access the kiosks. If the litigant is computer illiterate, not even an internet cafe close to home will be of assistance. All of this is a function of the situation in which South Africans find themselves, deprived by the educational system, deprived by poverty. So, yes, the system is good. Yes, the system does have advantages, but it will not be able to, at least not immediately, and not even in the medium-term period, it will not be able to address these problems, which are a function of disadvantage and deprivation. As I say, Court Online is definitely a welcome innovation, but in introducing it, it must be run in tandem with a system that will cater for the interests of those who cannot access it. This is something a new Chief Justice will have to look into quite closely. But as I say, there are certainly advantages, and indeed comments from users have been quite positive. The judiciary is not only about superior courts. The magistracy is an integral part of it. I am aware that there are certain issues that the magistracy wants to be addressed. As I understand, at least two issues that the magistracy is concerned about are its transfer from the Department of Justice to the Minister, you will forgive me, I never know when to call it Department of Justice and Constitutional Development or Department of Justice and Correctional Services. And I'm saying this because I think I've seen when reference is made to your one deputy that the CD is added, whereas when reference is to you, the CD is not there. Anyway, if appointed, I will engage the magistracy to listen to its concerns and see what needs to be done. Of course, since the magistracy is under a department headed by the minister will have to be engaged. I do understand that the question of the transfer of the magistracy has been on the table for quite a long time. If appointed, I would sit down with the minister and try to understand what the issues are, what the holdup is, whether even the very idea of a transfer is accepted or not. If not, also ask for the reasons as to why not. But to me, sitting here, I think it makes a lot of sense that the magistracy and judges of superior courts do have to be under the same umbrella. We are all judicial officers. Because I had dwelt or delved quite a lot on the issue I dealt with when you were questioning me, Chair, I just noted other points as cryptic bullet points because I had timed my address. I had done a speech converter, and by the time I got to the point where I am now, if I had not cut out the point about delays at the Constitutional Court and my vision for addressing that, I would not have been able to reach these bullet points. But now that I think I still have a bit of time, let me deal with them. But as I say, they are rather in the form of cryptic notes. I want to suggest that, to me, there is something that is quite important and which I consider to go to the dignity of those that we interact with as the judiciary. And this is something that is already highlighted, or rather, this is something that is highlighted in the article or address that I referred you to earlier, commissioners. There is what I wrote at a seminar about a feminist approach to the adjudicative process. And it also goes not only to that, but also to a wider subject of sexuality, sensitivity of courts. Let me just quote what the comments of the GCB have quoted from what I wrote. They say the candidate, and this is at paragraph 8.6 of the GCB comments on me. They say the candidate appears committed to ensuring that the Constitutional Court's jurisprudence continues to contribute towards the attainment of equality by women. And then they quote me where I previously said, the end point we should all strive for is to dismantle the patriarchal, sexist, and misogynistic elements underlying our judgments. We can reach that end point if, in our judgment writing, we consciously embrace the truism that women are equal to men, and that several phenomena affect women in a myriad of ways which are either not discernible or not readily discernible to men. These are issues that are quite important to me. These are issues that go to the dignity of people. In the full article, I deal quite at length with a number of cases that display sexist, patriarchal, and misogynistic attitudes of men towards women who appear before our courts as witnesses. In particular, those women, and I cite quite a number of cases, who are rape survivors. we need to be very careful. And if appointed as a Chief Justice, as I said, this was a paper I delivered at a seminar for judicial education. If I were, and this was just a once-off, but if I were to be appointed, this is something that I would truly, truly take up more seriously and very energetically try to sell to all my colleagues. Then, on the related aspect, sensitivity on questions of sexuality, there is something that we take very for granted, and yet it goes to the core of the rights, interests, and dignity of LGBTQ plus people. When I meet counsel, which I did for almost half a year last year, as a presider, because for I think maybe close to 90% or more than 90% of the time, I presided at all constitutional court hearings. When I see a man, or at least somebody who appears to be or looks like a man, and I'm sure most of my colleagues do the same, I will take that person to be a man, and I will say, Mr. So-and-so. But I have learned that this is a sensitive issue to the LGBTQ plus community. And we need to have a particular sensitivity to this. And maybe it is time that the judiciary considered inquiring what a practitioner's or even a litigant's or a witness's preferred title, or even no title at all, who knows, is. What the preferred, instead of just because the person has a beard, then you say, yes, Mr. So-and-so. We need to be sensitive to those if we are to give true content to our Constitution and to the dignity that it so seriously espouses. Then there are difficulties with regard to physically accessing costs and high costs, logistical difficulties, especially for those in rural areas. But even for those living just outside of cities, for whom travel to the central hubs where courts are is difficult and expensive. A Chief Justice coming in, because this again is an access to court issue. And because in this context I even refer to people living close to the city, but for whom it is still quite expensive to travel to courts. I know South Africa right now has serious financial constraints, but these are aspects that should exercise our minds. These are aspects, because access to court is not something that should be taken lightly. These are some things or issues that we should try to apply our minds to and see if, for example, instead of somebody who is poor and the only money that they have is to buy a loaf of bread and to be able to have food together with her or his grandchildren, somebody like that does not have the luxury of taking a taxi from, for example, Soweto to come to town in Johannesburg for a hearing. Is it not possible for the court in Protea, Soweto, to have some screen for that person to go to, listen to the proceedings at Protea instead of coming to downtown Johannesburg. These are issues that some of us may see as insignificant, but the fare to come from Soweto to Johannesburg, and I will emphasize this, may mean to somebody who is poor the difference between going to bed on an empty stomach or having food, even if it's a loaf of bread on your table. Now that we have seen that online hearings work smoothly, we may have to consider, in fact, that would actually be, how these work. It could actually be a springboard for us to do what I have just referred to. People watch on YouTube. Something like that could be taken to the Soweto court, to Protea. Of course, I'm just singling Soweto as an example. It could be taken to some community hall in some area, and then people, or maybe YouTube wouldn't quite work, but at least that is an indicator that the technology is there. I would also move for an amendment of the Judicial Service Commission Act with regard to the different levels at which the Chief Justice participates at Judicial Commission processes. The Chief Justice chairs the full JSC, but the Chief Justice also participates at the lower, if I may use that term, the lower processes of disciplining judges. And then as a practical measure, and this is something that we did when I was part of this body for 2 years, and at that time Chief Justice Mlambo was the Chief Justice. Around this issue, what we decided the Chief Justice should do was rather to delegate at that level and then to be able to chair the JSC. Because once the Chief Justice participates at that level, then the Chief Justice cannot again participate at the full Judicial Service Commission. But I think rather than coming up with a practical solution, I think there needs to be specific provision on how this should be handled at the level of the Act itself. And then also, what if appointed, I would attempt to say is more use of Rule 41A on mediation. There are times when I think mediation would come in quite handy. Those of us who are lawyers here will have had the experience of how strongly litigants feel about their cases. And unfortunately, sometimes even we as lawyers would side firmly with our clients and make no attempt to make them see reason. If my client is fighting, I am also in that fighting mood, and unfortunately, the litigant on that other side and my opponent are in that same mood. I think the idea of a mediator, not the judge or the magistrate, a mediator who is going to engage the parties and coming in neutral, that would I believe, assist our judicial system in the sense that we have a lot of cases before the courts, hence the backlogs that we have. If mediation were to work and get rid of cases that ought not to have been litigated at all, or at the very least, cases that are settleable, it would relieve the court of a burden that will then enable it, that is the court system, not just a single court, the court system, then enable it to deal with cases that it indeed ought to deal with. And there is an article, and I would, if appointed, just revisit it and look at the concrete suggestions made in it. There is an article written by one of the deputy judges, president of Gauteng, Deputy Judge President Roland Sutherland, in which he is advocating for more use of the mediation system. What I also want to have a closer look at is on case flow management, an innovation that I think is has borne fruit, and it is an innovation that was brought in by Chief Justice Mogoeng. Just one aspect that I think I want to look at and see if judges president would find it acceptable and indeed workable is whether, because I have, for example, heard sight of maybe one or two of the practices on case flow management, but what I have found is that it does not provide for the management of a case as it flows through the process by one judge. I understand maybe in the smaller divisions, I do not know, maybe it may not be all that practical, I do not know. But it is an idea that I would want to bounce off the judge's president. Because if I do one little bit in the process of managing a case and then I'm off and a colleague comes in, that colleague will not have a clear idea of where I was going with a case when I took a, yes, maybe sometimes it may be clear where I'm going, but if I do this and the case comes to me next time, I know exactly why I did what I did earlier, and from this point on, I know what I want. So I think it would add something to a process that I think is already good. So I put it no higher than saying that I would put it as a suggestion to judges president, see if they find it acceptable and workable. And then another aspect which is close to my heart is the question of arbitrations of commercial matters. There is a perception that wealthy South Africans, for whom, or in respect of whom, for the most part, you can read white, are not comfortable with having their cases heard or adjudicated upon by black judges. And the perception is that they do not have confidence in them. So, which is why those matters are taken out of the judicial system or our judicial system and brought before private arbitration. I would want to get to the bottom of that. I would want to, one, look at that very perception, and two, look at what needs to be done from our perspective as the judiciary. Is there, or what shortcomings are there? Yes, I do know that there are delays. Yes, I do know, like it takes a long time for cases to come to the stage of a hearing and so on. But I would want to just have a look at what we would be able to do to address whatever problems there are within our system. But of course, I think to a large extent, case flow management has eaten into the delays that we have been having on matters coming to court for hearing. So at least there has been an improvement in that regard. And then I would also want to say that nobody has the monopoly of knowledge, the monopoly of wisdom, the monopoly of ideas, intellect, etc. So I would approach, and for me this would be the first port of call, I would approach all levels of the judiciary, and this is something I would do immediately. I would meet the President of the Supreme Court of Appeal, I would meet the judges' president, I would meet the presidents of the regional courts, I would meet the cluster heads of the magistracy at district level, to get an idea of what the problems are from their perspective. And I believe that this would help inform the approach that I would take with regard to improving our judicial system. And of course, I must acknowledge the fact that an incoming Chief Justice would not be coming in on a clean slate. The Chief Justices before have done a lot of sterling work, and they set up templates. So one would, I've mentioned, for example, the case flow management, I've mentioned the introduction of Court Online, which has the two aspects that I referred to, and the introduction of the Code of Conduct for judicial officers. So a Chief Justice coming in would take in from that point and take the process forward. Those are my, if I was in court, I would say submissions, Deputy President.
Thank you, Justice Madlanga. In fact, you exceeded your 30 minutes by almost 20 minutes. So I was somewhat generous to afford you the opportunity to wrap up.
Thank you very much, Chair. Thank you, Deputy President.
I think this would be the convenient stage to take the mid-morning adjournment. According to our schedule, it should be 20 minutes. I make it 11:45 now. Shall we then resume at 12:05?
Thank you, Chair.
members of the commission to put such questions as they might have for you. And fellow commissioners, in accordance with the traditions of the commission, will those who wish to speak alert me, and I will allow them to do so in the order in which indication is made to me. Thank you, Honorable Minister.
Chair, may I just say that to the vision, there is no way that one cannot add the perennial problem of perennial and systemic problem of delays in the finalization of both criminal and civil matters. That is a matter that I if appointed, I would also want to look at. I will not substantiate on that. Thank you.
Thank you, Justice Madlanga. Okay. JP. Okay. No. Commissioner Malema, did you have your hand up? Okay, thank you. Commissioner Nyambi, did you have your... Okay, thank you. Thank you. Advocate Kane, have noted you. And you too, Commissioner Tsepe. I've noted you too, Commissioner Malota Tlepo. Commissioner Shabangu, I've noted you. Professor Slema. Commissioner Casey. Okay. Okay, Commissioner. I've got you already, Commissioner Dodov. And you, Commissioner. Okay. Commissioner Lucas.
Deputy President, I have my hand up virtually. It's Clemens Breitenbach.
Thank you, Commissioner Breitenbach.
Commissioner Brown's hand is also up.
And Commissioner Barnett, I've noted you as well.
I would like to be noted as well.
Yeah.
Thank you. I've made note of all the members of the commission who have questions for Justice Madlanga. Honorable Minister.
Thank you very much, Acting President of the Supreme Court of Appeal. And good morning, is it still morning? Afternoon, Justice Madlanga.
Good afternoon, Minister.
Thank you. My question relates to the separation of powers and the court administration model. What do you see as the role of the three arms of the state with regards to the separation of powers and in the development of the court administration model, with the examples of benchmarks that yourself as a judiciary might have done? And what do you think will be the role of the Chief Justice to ensure that this court administration model does materialize?
Minister, maybe because you preface your question with a broader question of separation of powers, I would say that constitutionally, all the various, or the three arms of state have carefully delineated powers. And in general, and I emphasize in general, each one of them must stay within its lane. Why do I say in general? I say in general because more than one judgment of the Constitutional Court, off the top of my head, I can think of the judgment in the matter of Heath. I think there was an earlier judgment which was penned by Justice Ackerman. I forget the name of that one. There may be one or two others. The Constitutional Court said that even though there is this separation, our model is such that you can never talk of 100% separation. There may be that area of confluence or area of a bit of mixing up. And how did this arise? In the context of the Heath matter, it arose with regard to the question whether a judge could head up the investigative unit, which at the time was even named after the judge, which it was called the Heath Special Investigative Unit. And the Constitutional Court said, no, that cannot happen. But in other contexts, like for instance, issues around the issuing of warrants of arrest, which in a way some might view as more executive than judicial functions. The court said, no, but because that requires the sort of application of the mind, which in a sense is the exercise of a judicial function, there allowance can be made for the judiciary to perform those sort of functions. But going back to the broader issue of the separation, and the last part of the question that you zoomed in on, for there to be a clear understanding of the separateness of the judiciary, there was a need, and I do subscribe to that idea, for the administrative support to the judiciary to be an entity that is identified with the judiciary, and that resulted in the creation of the Office of the Chief Justice, which is nothing other than a government department which services the judiciary. That, in my mind, does accord with the broad idea of this constitutional separation, and not only that, even the need for it to be seen to actually exist. Then, with regard to the participation of the Chief Justice in that landscape, I think I did, that is earlier, I did touch when I dealt with my vision with regard to the sort of Chief Justice that I would like to see, a Chief Justice who leads the judiciary in terms of setting up a worthy and lasting jurisprudence. I did touch on the fact that, in my view, a Chief Justice should not be a super secretary general. Those administrative functions that, for example, whilst the judiciary was under the Department of Justice, were performed by the Department of Justice under a Director General. Those functions must be performed by the Office of the Chief Justice under the directorship and headship of the Secretary General. That is terrain that the Chief Justice should not stray onto. And I might even mention that there will be certain administrative issues that we as judges sometimes approach the Office of the Chief Justice on, and not being aware of the nitty-gritty with regard to prescripts applicable to them. And the SG never wavers, and she just tells us that, Judge, the prescripts do not allow that. I respect that, and that is something, if appointed, that I will honor. But as I said earlier, I would want to know, and I think the SG does cooperate in this regard, I would want to know what is happening, what must I know, what must I be told. For example, because I would not want to see something that has been out there for a while and learn of it for the first time from the media.
My second one relates to the matter you spoke about of case line and the modernization of the system. And I heard you speaking about the fact that it has only been done as a pilot in Gauteng. Has there been any efforts that you have been involved in with the Concord or in your role in the Judicial Institute to infuse modernization and digitization of the entire court administration system? And if not, what will be your role as a Chief Justice to ensure that this is harmonized for all judges, for all magistrates, and the entire processes of the judiciary?
We are now in the fortunate position that, as I indicated to you, Minister, the process is right at the tail end of the pilot project. Once the CRM dynamics comes in, is interfaced with case lines, and it is, again, for a very short time, the two interfacing piloted in Gauteng. My understanding is that within a few months thereafter, it is going to be rolled out initially to a few high courts, maybe up to about 5. That's my understanding. I may not be accurate on that information. And the question may then be, but why not to all high courts at the same time? My information is that you do not want to go to a whole lot at the same time because you want the support people who attend to the actual rollout in physical terms are of a limited number, and you want to be able to grapple with a lesser number. And then once it is in place in the 5 plus Gauteng, then you roll out to a few more until you are done with the High Court. With the explanation that I have been given, which is the reason why a phased rollout, I think I must accept that. I must settle with that. And then also, my understanding is that implementation is meant to be as soon as possible, perhaps to take part simultaneously with the first phase, that is at the Constitutional Court and Supreme Court of Appeal, to take place simultaneously or roughly simultaneously with the first rollout to some of the high courts. I must confess at this stage, Minister, that based on the information that I have, I am not aware of the intended processes with regard to rollout to the magistracy. But if appointed, and with the advantage of the system already being in existence, that is both the CRM and case lines, I will be on top of things with regard to how do we get this to all the courts in South Africa. That nitty-gritty is something that I believe one can easily be on top of.
Thank you, Judge President.
Thank you, Honorable Minister. JP Tlaletsi.
Thank you, Acting President, and good afternoon, Justice Madlanga.
Good afternoon.
We spent the whole year together, but you only meet for the first time physically today.
That's terrible.
It's terrible, yes. You've covered most of the issues that I wanted to raise, but for information on the case flow management model that is being used,
yes,
it was envisaged that the allocation of cases to judges will enable them to go through with those specific cases up until they are trial ready, and that judge would not be the one to do the trial.
Okay.
In the divisions, not smaller, but with fewer judges,
yes,
like Northern Cape, that system is how it's operating at the moment.
Okay.
And I can say it's a success.
Thank you. Then I'm happy that at least I had an idea of pushing for something that in fact the courts have actually thought of. So I was not completely off the rails. Thank you, Judge President.
Thank you. And then on the issue of the Super DG, I think, or Super SG, I think that's a very important aspect because there seems to be a lot of misinformation that the Chief Justice can do as he or she pleases and interfere.
Yes.
And obviously, the Public Service Commission, the Public Service Act does not apply to the Chief Justice and the Judiciary. So there are people who are officials who deal with that as the support structure to the Judiciary.
Thank you.
Then my next question is, have you considered informally, of course, conducted a skills audit of the Constitutional Court in particular and the Judiciary, particularly the superior courts in general, where we could be lacking and how we could improve?
Formal skills audit, definitely.
Informally, that's what I'm saying.
I'm so sorry. Even informally, I must confess that is not something that I have done. But maybe what I could say off the top of my head and based on my experience as a legal practitioner, and which of course fits into the judiciary, is that maybe at the initial stages, when a colleague comes to the bench, and let me be specific and say black, and I could even go further and say women. At the initial stages of coming to the bench, there would be disadvantage. Disadvantage in this sense. Let me take a few steps back and go to my university days, and I must immediately apologize to commissioners to the extent that I will now sound like I'm blowing my own horn. At Rhodes University, as students, we were quite a small faculty in my years. I think we were around 25. But I could, without any fear of contradiction, say I am certain that I was within the top 3. Students who gave me a run for my money were Bede Harris and Myron Zlotnick. The few distinctions that I got at Rhodes University would qualify as what is known as commercial law. But when I went to practice, did I ever get commercial work? No, I did not. And we all know what that is a function of. It is a function of the South African economic situation. Who holds the money, in whose hands is the wealth, and therefore in whose or who generates that commercial work. It's obvious. So the closest I got, before going to that, now if I had performed as well as I did in my LLB at university, even including in commercial subjects, what would have stopped me from excelling in commercial practice? I do not believe that anything would have stopped me. I did not get that commercial work in practice. The one case that could have qualified as commercial work, listen, I was in practice for years and years and years, and I'm talking about one that I remember off the top of my head, was a matter in which I was led by the late Justice Sikweiya. The closest we got to commercial work was, matters involving the law of contract and debt collection. You'll remember your colleague, Mr. Humphrey Lusu, he gave us a lot of work from the company that owned the Sparks Holdings, which was called RNE Holdings, and of course we got a lot of work from you as well, acting president, and many other attorneys. But it did not truly qualify as commercial work. Where am I going with this? So we did mainly administrative law work, constitutional law work. So when you come in, and also, other colleagues in practice did RAF work, other colleagues did only criminal work. Now you come to the bench. You will, at the initial stages, you will definitely be disadvantaged. But take, for example, at the Constitutional Court, we had the matter of Ascendis versus Merck, and you hear these concepts about inutility and lack of innovation, this and that. You have to sit down, apply your mind as seriously as you can, and try to get on top of things. You just have to do that. But you are at a disadvantage because somebody who has practiced that kind of law with them, they already know what that concept is, what that other concept is, and they start far ahead of you. You start way behind. But I emphasized the point that initially you are at a disadvantage because with time and as you get exposed to this kind of work more and more, and if you apply yourself hard enough, there will be catch up. You should be able to catch up. I don't know to what extent I have answered your question, Judge President.
Yeah, no, you did,
Yes.
and maybe even Sajay can play a role as part of judicial training.
Yes,
to empower those so that they should not be disadvantaged for purpose of promotion or
Yes.
ascending the ladder within the judiciary.
Yes.
Yeah. On the side issue, you did mention that at least for the latter part of last year, you were sort of part of leadership of the court, constitutional court. You were presiding in most matters.
And I chaired virtually all conferences.
Of course.
So I actually performed, you are quite right,
Yes.
Judge President. I performed without any title, not even as an acting Deputy Chief Justice. I performed the functions of a Chief Justice.
That should have given you an indication about the respect and the command you have over your colleagues in the court. Can you say anything about that?
I believe that I do command the respect of my colleagues, both permanent and acting colleagues do approach me on the side for my views, sometimes just on process matters, but in particular on cases themselves, judgments. And if I will not embarrass you, you are actually one of those colleagues who have approached me on what I think. And I might even place it on record, Judge President, that where maybe, and I guess because of the problems or issues associated with the delays, where maybe there has been a bit of delay on my part to comment on a colleague's judgment, on occasion, some colleagues will approach me on the side and literally ask for, I don't want to put it higher than that and say demand, but ask with a bit of insistence for my views on draft judgments. So I would say that that is an indication. And as I said, and I want to emphasize this is not just acting colleagues, but it is permanent colleagues as well. I want to say that this does speak to the respect that I command from colleagues.
Yes. Just to clear the air and to eliminate any form of confusion, these are on matters that you with the colleague presided on.
Yes, it is quite true. But in fact, I must say though that this is something that has been happening even before I started presiding. For a while now, yeah, colleagues have sort of been approaching me for my views, yeah. And of course, this has continued even when I have been presiding, yeah.
I see. Okay, something that I do not recall you mentioning in your vision. How do you propose to deal with the media as the Chief Justice?
Now you want to put me on the spot, Judge President. This is a subject that raises constitutional issues. Section 16 of the Constitution, to be particular, from both sides, there is the one side being people who raise issues against the judiciary in the media, and the other side being how, if at all, the judiciary should respond. And all these, as I say, turn on what the Constitution says. And Section 16, as you know, guarantees each and every one of us the right of freedom of expression. So we should never lose sight of the fact that people are entitled to criticize us. We are not beyond criticism. And criticism can and at times must be robust, and we just must take it on the chin. But sight should also not be lost of the fact that we perform an important constitutional function. We are, after all, the ultimate arbiters as to what is lawful, as to what is constitutional, and all of this turns on the rule of law. For South Africa to continue being a country that respects and subscribes to the idea of the rule of law, courts should continue to function as courts and in the manner in which they should be expected to function. Where am I going with this? The criticism, which I immediately acknowledge as I did at the beginning, the criticism should never go to a level at which it will bring the courts to a state where they no longer enjoy the respect that they should enjoy from the general populace. Because once that stage is reached, then one may just as well say that the idea of the rule of law in South Africa has gone out through the window. So the judiciary should continue to enjoy the legitimacy and the confidence that it should have in order for the rule of law to continue functioning properly. So as much as I accept that there should be criticism, it should be criticism, one, that is fact-based, and two, it should not be criticism that is for no other reason. One, not being fact-based and calculated to bring the entire edifice of the judiciary into disrepute. After all, as both Chief Justice Mohammed speaking extracurricularly or outside of court, and Justice Grichla speaking in court in the matter of Mamabulo, the judiciary does not have a purse, it does not have police, it does not have an army. It depends on the legitimacy that it enjoys, the confidence that it enjoys. once a level is reached where people criticize it in a manner calculated to bring it into disrepute, that takes away the one thing that makes it possible for it to operate. Now, let me come into the last part of your question, what should we do? There is a lot of learning on the subject, and that learning does say that, well, judges also, as I think I said in my preface, do enjoy freedom of expression. But for them, there are certain limits, and for good reason. Those limits are at, for example, 2 levels. The first level being a judge should be careful, for example, not to comment on court-going matters which would give an impression of the judge being biased. That should be clear to everybody. Then there is another level, and in a sense, it is related to the first. And both these issues go to the question of the independence of the judiciary and the need for it to conduct itself in an impartial manner. So the second aspect is provided for in the Code of Conduct, and it says that judges should not comment on political controversies. This is easier said than done, as the expression goes. In practice, it's not quite easy to grapple with it, but maybe it's quite easy actually. The Constitution is such that there are lots and lots of political implications around it. The very idea that it lies with the courts to invalidate acts of parliament. Acts of parliament come about as a result of a political process. The very idea that courts can invalidate the conduct of the executive, starting from the president to ministers, that conduct is something that happens in a political context. And even when you, then outside of that, even when you look at the Constitution itself, take for example your socio-economic rights, those in and of, it inheres in the nature of those rights that there will be policy-laden issues. Even the very idea that because ordinarily when you take the rationality principle, you don't question the reasonableness of the conduct of parliament, for example, or whoever the actor was. But when you come to socio-economic rights, it is inbuilt in those rights that you actually look at what is reasonable. So a court can actually question the reasonableness of what another arm of state, parliament, or even the executive has done with regard to something that impacts on socio-economic rights. So I'm touching on all of this in the context of judges commenting on political matters. And what is the relevance of all this background that I have given? It is this. In the context of an adjudicative process and deciding whether or not the conduct of parliament, the conduct of the executive, or even issues arising from whether what was done by the other arms of state in the context of socio-economic rights is reasonable. The issue of political questions is there throughout. Therefore, in that context, because you are adjudicating a live case before you, you cannot avoid, in a sense, but of course, you are concerned with what does the Constitution say? And if where it takes you is to knock out or invalidate a political act, so be it. It is fine. That is our constitutional architecture. But outside of that, that is where then issues arise. But we are in the fortunate position that the Code of Conduct says, steer clear of that. Steer clear of that. Now, back to the broader question, what do we as judges say in the face of, for example, that criticism that I said may get to a level where it is unacceptable? What do we as judges do? I said there's a lot of learning on this, and there are differing approaches. And the one approach is that it may be something that should be dealt with at a leadership level, and that is an approach, for example, that Chief Justice Mogoeng used together with or accompanied by Deputy Chief Justice Moseneke and I think President Mpati, if I'm not mistaken, and they approached the President, President Zuma at the time, at the level of, that is Chief Justice Mogoeng as the head of one arm of state and President Zuma as the head of another arm of state. And out of that process came out a joint statement in which there was agreement on what is acceptable criticism and what is not acceptable criticism. Now, I am sure that a follow-up question would be, but is that the only possible approach? On the learning that I have gone through, it is said that a leader of the court may be entitled at times. It is not something, we cannot all the time run to the media all the time. But there is a lot of learning that says, in certain or under certain circumstances, the head of the judiciary, it may be perfectly proper for the head of the judiciary, under certain circumstances, to go out there and address head-on the unacceptable criticisms, the sort of criticism that, if allowed to go on and on and on, might have the effect that I earlier outlined as being, or potentially being injurious to the very idea of the rule of law.
I see. Thank you. And then at another level, or the second leg of the question would be, there is a lot of misinformation about the functioning of the courts and how cases are decided. And one cannot expect the Chief Justice or the leader of the judiciary to be addressing the media from time to time on these other minor issues, but which are so important to the public to understand what is happening. An establishment of an office within the heads of court, chaired safe by a retired judge who will deal with all these minor issues to conscientize the public of the functioning and what is happening in the courts. can that not be of assistance? It's just a thought that came to me. I was just bouncing it
As
on
I'm
you.
speaking, my understanding, I will not reject that at all, Judge President, but I will add this and say, my understanding has always been that within the OCJ, there is an arm that handles the media. I think they have a certain expertise of dealing with the media. So perhaps what about merging your idea with what is already in place? That focal point, the focal point that you prefer should be or rather you suggest, you don't prefer, you suggest, should be a judge. What about that focal point? Be getting all these issues, and then with the experience of what we as judges do, then filtering it through to the OCJ, for the OCJ to then be the entity that actually goes out. I see no problem with that because the OCJ is our own entity. It is an entity that exists to support us as the judiciary. I do not know how
No,
to
that's
think
what
or
I
how
had
to
in
think.
mind actually, and say we always react to what is there in the public, but we don't take proactive action as the judiciary for public education. on that.
But as you say, caution should be exercised. We cannot all the time. There's criticism of this. We run and we try to react to that. Again, there's another criticism. We run and we try to react to that. We should be careful not to do that. Yeah.
Thank you, Acting President.
Thank you, JP Tlaletsi. Justice Madlanga.
Thank you, Judge President. Yes.
Could I ask you please to be concise in your answers, bearing in mind that I still have a long list, about 20 of members of this commission who have indicated that they have questions for you, whilst at the same time, adequately responding to the questions. But
I will try to do my best.
do your best to be concise.
Thank you, Acting President.
Commissioner Dodov.
Thank you very much, Commissioner. Good morning, Justice Madlanga.
Good afternoon, Commissioner.
Are you good?
I'm good, thank you very much. How are you, Commissioner?
Firstly, let me start by saying I looked at your profile, your record throughout your career. It is quite impressive.
Thank you, Commissioner.
You admitted at a very young age as an SC, as a judge, you resigned, you chaired important commissions, or you were part of the important commissions in this country, and ultimately you became a member, you became a judge at the Concord. Very, very much impressive. I also read some of your judgments.
Thank you, Commissioner.
I missed something, and I want you to allay my concerns.
Yes.
Out of all of this, I don't see your leadership role. And this position you are applying for, it is leading the judiciary in this country. What is your take on that?
I will say there is demonstrable evidence, Acting President, please forgive me on this one, because it goes to the core of why I'm here. I will not be able to be brief. Please allow me. Thank you, Acting President. There is demonstrable evidence of my leadership skills. I have led at various levels, and let me emphasize up front that I have even actually led a court. I was acting judge president in Mthatha. Let me quickly itemize the things that I have done in leadership positions. I was for years a member of the executive committee of the Transkei Advocates, Transkei Society of Advocates, and then second, I later became its chairperson for 2 terms, and I could only have been retained because there was a feeling that I could lead. Third, for 3 years, I was deputy chairperson of the Competition Tribunal. That is an entity that is as good as a court. Fourth, before my appointment to the Constitutional Court, I was chief evidence leader in the Marikana Commission, leading a team of 7 counsel, 3 of whom, including myself, were senior counsel. And what I must highlight in this regard is that it was not only about the leadership of my 7, we were a total of 7 counsel, leadership of my team. But I also exercised functions that related to the entire operation of the commission, that is outside of the chairing part. And I think Advocate Mpofu will support me on this. He will remember that I used to chair meetings, and there were quite many, of all those legal teams, and that was, we were far more than the people gathered here. Many advocates, many attorneys, those who remember, you will remember us sitting on stage when we were still in Rustenburg. When we came to Pretoria, you couldn't quite see because the attorneys, the advocates would be mixed up with everybody in the gallery. I chaired all those meetings, and lawyers being what they are, those were very difficult meetings, but I think I did my job well. But of course, it is Advocate Mpofu who would be able to comment on whether he agrees with it. Of course, he and I, at the level of counsel now, we had our skirmishes and boxing matches. Fifth, I am now in my 5th year as editor-in-chief of the South African Judicial Education Journal, a demanding job. 6th, I am currently co-editing with Judge Dambuza a book to be published to mark 10 years of the existence of SAJA, and I am heading that team. And contributions are going to come, that is, chapter contributions to the book are going to come from fellow judges. 7th, and most importantly, as I said at the beginning, I did lead a court as acting judge president of the Transkei High Court with tangible results. With tangible results. A leader, all that a leader needs to do is to come in and do 2 things in the main. There may be a whole lot of others. 1, decide where you want to take the institution. And 2, identify problem areas and come up with solutions for those problem areas. And then the next step, we should also be immediate. Implement immediately. I came up, I did not act for a long time, but I came up with tangible results, and one worth highlighting is that there used to be bottlenecks at circuit courts at the Transkei High Court. Circuit was done, a circuit would only be for a week, and judges hardly ever finalized cases. They would pick up part heads. I came in, I immediately identified this as a serious problem, and I decided there and then to increase circuits to 2 weeks. Yes, 2 weeks is not that much from 1 week, but because we were a small division, it would have been difficult for purposes of what happens at the center in Mthatha itself, to have judges out on circuit for long periods of time. But that one small change did bear fruit, and it did so immediately. Judges were better able to finalize cases and picked up lesser part heads.
Okay, I'm clarified. I want to follow up that question.
Okay, all right.
Yes.
Yes.
And people who will ultimately or who occupy a position you applied for must possess a modicum of good temperament, a modicum of good judgment. Do you think that you have a good state in that respect?
I believe I do, and I think people who have worked closely with me before would attest to that. I think acting President Petse, I think Justice Tlalesi there, and even as advocates, I would say Advocate Mpofu, Advocate Madonsela, whom I even led. I think all of them will attest to that, I believe.
Okay. Now, one of the points that Justice Peter raised about the attacks on the Concord is that of the quality of judgments. And he said, those who criticize the Concord says, sometimes you are incoherent, your judgments lack reasoning, and you use strong language, and sometimes you are very combative. And I want to check with you, do you believe in that? And if so, how can we improve and mitigate that kind of situation?
Let me say that it's very difficult at the level of, the comments about incoherence and so on. It's difficult to grapple with it, not knowing the specifics. But to the extent that there is a basis for criticism, I want to say that with the new system that we have introduced, and which I believe is going to free up a lot of time for us, we are going to be better able to focus at what we do, attend with a bit more detail to our judgments, and even the editorial errors, citations and so on that we have even been criticized for, and quite correctly. I think with a lot more time on our hands, we will be able to address those. On language, there again, I think I would prefer to have specifics.
Okay.
I thought we are fairly collegial towards each other. Yes, sometimes you may be strong in your opposition, but yeah, I think I would prefer specifics. Yeah.
Okay. Now, when
Apologies, I'm sorry to intrude Commissioner Dodovo. I just want to ask Justice Madlanga to please pull the mic closer.
Oh, gosh.
Because some commissioners are battling to hear you.
Oh, I'm so sorry. Am I
now,
better now, Commissioners? My apologies,
Oh, okay, now when you shared your vision for the judiciary, you mentioned how you can improve case flow management, emphasize on issues of mediation, systems that must be put in place, and so on. In short, just share with us your vision for a transformative judiciary that takes into account the realities of our country. Just brief.
that is an issue that is linked to a whole lot of facets of the South African economic, social, or perhaps socio-economic situation. And right now, when you maybe have ideas around certain things, there are also, right now the problems of this cannot be done because there are no resources. I raise this in this context. It is a reality, unfortunate though it may be, that somebody who is not legally represented will not be able to marshal their case in the same manner as their opponent, if their opponent is legally represented. Now, if we did not have resource constraints, there could be a way of trying to make justice or access to justice to be a reality. Yes, it is so that on the criminal front, there is Legal Aid South Africa, and which comes in automatically in criminal trials. But with civil cases, there is the needs or the need test. And the vast majority of South Africans do not qualify under that. Somebody who could be classified as poor will easily be said that no, you are too rich for us to be able to assist you. So they fall off the net as long as you do not meet that needs test. So whatever ideas one might have with regard to trying to address the problem and to even out, legal representation before us, you will always be hit by the problem of resources in South Africa. And I must admit that I am unable, as I'm sitting here now, to wrap my mind around how do you practically address that.
My last question. Criticism versus attack. How do you separate that? For me, I think there is a thin line, or it depends on how you view it.
I would not distinguish between the two. I think for me it would more be the content. It's more the content, because some people may say this is an attack when all it is it's criticism. It's more the impact. Does it reach the level that I earlier referred to when I was responding to Judge President Tlaletse?
What I wanted to establish was, since the advent of our new democratic order in 1994,
yes,
with the transformation of the judiciary, do you think the participation of historically disadvantaged individuals have improved the situation of transforming the judiciary as it ought to be, or not?
The short answer is yes. This is also a subject I have written on and published an article on. out of several points that I make in that article, I also say that transformation is not for transformation's sake. You know, it's not just about having the different colors or races, but a person's outlook on life brings something to the table. I, as a black person, or a woman as a woman, may have a perspective or idea about a matter that may be totally different to, in the case of a woman, to a man, or in the case of a black person, to a white person, you know. And a case can actually turn on those perspectives. And as a man, I may completely miss something that a woman would see. And as a white person may completely miss something that I as a black person would see, and vice versa. And I will not use the vice versa when I'm addressing the question of, you know, the women. Because we as men, and because of how we have been brought up and how we view them, you know, patriarchy, misogyny, sexism, there may be a certain idea about women. And I'm not apologetic about this, and as I've said, I've written about it and written against it, you know. Women may see things differently from us, and I'm advocating for us to push ourselves as hard as possible to also see things the right way. So yes, there has been transformation, and not just that, practical value in it.
Thank you very much. Thank you very much, Justice Pitzer. Thanks.
Thank you, Commissioner Dodovu.
Follow up, Justice Pitzer. Lamola.
Yes, you may proceed, Honorable Minister.
Yeah, thank you, Justice. When you answered JP Tlaleng, I understood you. But now when you answered Commissioner Dodovu, you have left me a bit confused on the issue of criticism and attack. I want to get your view. What is, in your view, should be deemed or viewed as a constructive criticism or criticism, personal attack, or even insults to a certain extent, and who should determine it?
Minister, I guess the point I was trying to make is that I'm not sure that I want to focus on the tags. It is more, one, the effect, and two, the content. You may classify it as an attack or criticism, but it's more the content. For example, something that is completely factually unfounded. But because people are not aware, and because people will not all go to the source material, or will not be able to interrogate it, but will just take it at the level that it has been said. And it is also quite important. It is also quite important who says it, you know. So the impact that it will have, possible impact that it brings the judiciary into disrepute in a manner that may adversely affect the rule of law. That for me is the issue. And whether you call it attack, you call it criticism. And I think when I was talking, rather responding to Judge President Tlaletsi, we were talking criticism throughout.
Thank you.
Just a follow-up.
Thank you, Minister.
Commissioner Malema.
So, Justice.
Good afternoon,
Thank you.
afternoon, Commissioner.
No, I didn't want to come in now, but you raised a point earlier about which was raised by the acting president. about the huge criticism on the Constitutional Court, its inability to deliver judgments on time, right? And you came here and said, well, you are correct, we are unable to deliver on time, but this is what is going through. So if I say the Constitutional Court doesn't deliver judgments on time and all that, and I'm a layman, I'm not inside there, will I be attacking the court, or will I be justifiable to say the Constitutional Court is delayed in delivering its judgment? Would it not take a good judge and a good leadership to accept that, no, you are correct? But the reality of the situation is that this is what we are confronted with. But some short-sighted politicians may see that as an attack on the judiciary, because I liked what you said earlier on. No, you are correct. We take long, but this is what we have been subjected to. And in responding to that, this is what we are coming up with to resolve that problem. But some myopic leaders here have been actually attacking those who say Constitutional Court takes long to deliver judgments. Is that an attack, or is it a constructive criticism?
That's constructive criticism. Had I not been taken off my script on my vision by the acting president, asking me questions that relate exactly to this, in my note here, in my opener, dealing exactly with that point, Commissioner Malema, in so many words, I say, this is fact and I accept it without question. So I would take that as constructive criticism. Thank you.
Thank you, Commissioner Malema. Commissioner Magwanisha.
Thank you, Acting President. Good afternoon, Justice Madlanga.
Good afternoon, Commissioner.
I just have a few questions. One, bearing in mind that your vision must be translated into strategy and to plans. And in that process, there might be resistance to change. Will your vision be implemented in 3.5 years?
In my view, 3 and just more than, of course, depending on when the president makes an appointment. 3 and about 3 years and about 6 months, in my view, is actually a very long time. And I want to say, please just bear with me, Commissioner. Where's this? Yeah. I do not, for example, I do not think that my vision will be things that are so unrealistic that they are likely to meet up with a lot of resistance. But as I said, either right at the end or at the beginning, nobody has the monopoly of wisdom. I am going to consult with the heads of court on the ideas that I have. And as part of my vision, I have also said, I will get ideas even from the heads of courts themselves, so that what comes from them is, in a sense, part of my own vision. Logically, therefore, there will not, or it is unlikely that there will be any resistance with regard to ideas that come from the heads of courts themselves. And by heads of courts, I'm referring to all levels, from the Supreme Court of Appeal to the District Magistrates Court. And with regard to my own ideas, I will try to push for them. I could spin your question, Commissioner, and say, if a point that you bring to the table, because you are saying if there is resistance, if there is no acceptance, I could say you may have 12 years as Chief Justice, but that does not guarantee you that that which is seen as unacceptable will suddenly become acceptable just because you have 12 years. So I come in with ideas, I try as hard as possible to sell them, and I implement immediately. And I want to say, in countering this idea that 3 years is short, I want to say that there are examples of people who have turned around courts or improved on them in less than a year. I'll give the example of somebody who is well known to this august body, Judge President Benenge, who is the Judge President of the Eastern Cape, and who has made the Eastern Cape High Court to be one of the better performing high courts. I have also said that I myself, as a leader of a court, even if in an acting capacity, was able, within a very short space of time, bring about changes. So 3 years is a very long time. As I said in response to another question earlier, all that you need to do when you come in is to decide where do you want to take this institution and what are the problem areas, how do you address them, and you implement immediately. When you depart after 3 years, 6 months, or whatever the period is, templates are there. And those templates are not likely to be thrown out by your successors just because they were made by you. If they are good templates, those will have lasting effect. Chief Justice Mogoeng is the one who brought in case flow management. He is the one that introduced Court Online. He's the one that put together the norms and standards. We are not going overnight to just throw them away because they were introduced by him. Question is, will I within that period put on the table templates that are workable and will have a lasting effect? Thank you, Commissioner.
Thank you, Justice Madlanga. Have you led in a situation where there are different stakeholders with competing interests? And how have you protected the interest of your organization whilst promoting sound relations with other stakeholders?
I think you may have seen in my CV that I actually led an entity that was called the Exchange Control Amnesty Unit. At the beginning we were 9, and in the end we grew to 25 as Amnesty Unit members, but the entity itself had a staff complement of around 100, and which I led with success. It had different interest groups in the sense that there were half of the officials were from SARS and half were from the South African Reserve Bank, and yes, it was a project pushed by both sides, but the interests and the ideas were not always the same. And I led that with success, and at the end of that project, the Deputy Minister of Finance then, Jabu Mleketi, spoke very highly of how I had led that process. I actually have the quote of what he said somewhere here, but I will not go into that.
Thank you very much, Justice Madlanga. SADC is faced with a serious threat of terrorism. Do you think that this might have an impact on our jurisprudence? For an example, the issue of individual rights versus national security.
I do not, I must admit, it's not a question that I've applied my mind to, but I do not at the moment see how it would affect individual rights, at least in South Africa, not at this stage.
I think the last one, how will you strengthen relations between the judiciary and parliament, in particular the Portfolio Committee on Justice and Correctional Services?
I would say that nothing beats interaction, Commissioner. And I understand that you chair that that committee right now. Nothing beats interaction. I would definitely try to engage when there is a need to engage and discuss matters of common interest, of which there are many, because your committee and the judiciary are concerned, are both concerned with justice. So,
thank you very much, President. Thank you very much, Justice Madlanga.
Thank you, Commissioner.
Thank you, Commissioner Magwanisha. Commissioner Singh.
I hope it's just before lunch, Acting President. Thank you very much. Good afternoon, Justice Madlanga.
Good afternoon, Commissioner.
I want to start my first question with what the Honourable Minister asked in the beginning about the arms of state. And we know what the three arms of state are. And to the extent that a vote 27 was established and proclaimed by the President in 2010, the office of the Chief Justice, my view, and you can tell me if I'm wrong, is that one would think that that vote came about to give the judiciary and the office of the Chief Justice its independence. Of the judiciary can be established if the budget which controls vote 27 places the minister as the executive authority of that budget.
I must say, maybe because of how I have been schooled as a lawyer, instinctively I just have problems, you know, as a judge, and two, if I'm appointed as a Chief Justice, to the very idea that there's a budget, it is under me. And if it is under me, it places me in a position of having to yes, you say the accounting officer will be the SG, but the notion of, you know, this budget is under me, I think it places, of course I'm thinking off the cuff, it just instinctively, I just find that a bit difficult for me. The idea of, in a sense, you know, having something to do, even if I'm not controlling it, but the very idea that you are I'm sort of in the same position as the minister with regard to that budget. I have difficulties with that, but it's something, if appointed, I would try to apply my mind to. So I'm not outright dismissing the idea, but this is just my instinctive reaction. Yeah.
Thank you for that you're not dismissing it. I think it's something that one needs to engage with.
Yeah, and I guess there is also the so-called international best practice. So one could even look at what other jurisdictions do in this regard, and that could help inform the decision that one takes ultimately, Commissioner.
The reason I raise this, it's also applicable in another arena where we serve, and the Honourable Speaker would know about this, where the executive, the cabinet, is accountable to Parliament, yet the budget of Parliament falls under an executive member, which is the Minister of Finance. So there's a bit of, who controls who. Parliament should have its own budget and be able to manage its own budget and not be constrained by what the executive has to tell us in terms of how much money we get. But I'll leave it at that one.
Yes.
The second question would be about the delays, and I think Honourable Commissioner Malema spoke about the delays.
Yes.
Now, justice delayed is justice denied. And I know of some, I was informed of a case, Masugu and others versus the South African Human Rights Commission, for which for the last 2.5 years there hasn't been a judgment.
The initial hold-up on that one, though, was the Kwelane matter. The Masugu matter, I did not sit in that matter. I recused myself because of prior engagement as counsel in another matter a while ago, but the issues were related. So I'm not mentioning that to say, no, don't blame me, not at all. But the reason for the initial hold-up was in Masugu, on my understanding, there was no constitutional attack. I think it was more about the utterances themselves. Whereas in Kwelane, there was a constitutional attack. Now, if Masugu had been decided, put it this way, if Kwelane were to invalidate, which it partly did, the act in issue, then that had an impact or a bearing on the Masugu matter. So the Masugu matter was shelved until the Kwelane matter was decided. So it was only after Kwelane had been decided. And I do understand in practical terms it would have been difficult for my colleagues to even start writing the judgment. You are writing the judgment going which direction? If Kwelane is still being written, it's in the pipeline. That is my understanding of the delay in, at least as I say, the part of it.
No, thank you for that, Justice.
Yes.
And you see, it brings me to the question of modernization of the judiciary.
Yes.
Now, you are in the hot seat, and I'm sure you must be also thinking about the day you'll sit in the seat of the Chief Justice, if the President approves your appointment. Have you given any thought to how you would like the judiciary to be modernized in keeping with other countries, African countries, countries outside of Africa, so that perhaps, COVID might have been a good thing and a bad thing because it brought with it the virtual sittings. Now, have you any ideas of how you would like courts to function in the future so that these delays do not take place and you make it more friendly for law practitioners, for litigants, etc.? Have you had any ideas? Do you have any ideas that you can place on the table in that regard?
If we did not have the two seriously different, I will loosely say, communities in South Africa in the sense of the haves, have-nots, one would have said the best is caught online, what I described earlier, and I will not go into detail with that. But I immediately said there are problem areas there for the reasons that I highlighted. In the so-called developed world, this Court Online works like a gem. It works perfectly because even the youngest child is computer savvy and all of those things. So, and also they do have the resources. Everybody has access to all of these things. So with us, the problem always goes back to resources, access to money, and the use of it. But as you said, even at the level of judges, my understanding is that there was resistance to Court Online, but uptake increased as a result of COVID. So in a sense, COVID had positive results. So, but because there has been that initial uptake and acceptance, it should be much easier for other courts to accept the system. But one would have to apply one's mind on how do you address these two worlds. But the problem is, and I think it's quite fundamental, the problem is it will probably go back to resources again.
Thank you. I've heard the word resources many times. I think we've all heard the word resources many times. And we understand the constrained resources that the country is facing to.
Yes.
But if we want to deliver a judicial system to the people out there who don't have to wait for years, who don't have to languish in prison, bail for years on end without the matters coming before court, then, Honourable Minister, we need to do something about resources. And you've got parliamentarians here that will support an increase in that budget. So we just hope if you are appointed Chief Justice, you'll have a serious engagement about resources with the Honourable Minister. My last question relates to the safety of, there are concerns about safety of judges, of witnesses, those in witness protection. What ideas do you have? What can be done to ensure that there is a relative degree of safety of judicial officers and people who are whistleblowers?
Commissioner, let me not even try to pretend to be clever. That is an issue. I have not applied my mind to that. I will not pretend to have any answers or try to think off the cuff.
Thank you, Acting President.
But certainly it is something that if appointed, now that you've raised it with me, I would definitely apply my mind to.
Thank you.
Thank you, Commissioner Singh. Is it perhaps...
On a follow-up, Justice Madlanga is... I don't think you need to apply anything on it. You are there, you are in the space.
Yes.
Maybe let me put it differently. Is there a security threat on judges?
I am aware that there have been incidents which of course have not been and could not be publicized, but on my understanding, quite few. But if there is, there are the few, that in itself should be cause for concern. But I must confess, I am not at all aware of the details. I'm not aware of the details.
Thank you, Commissioner Mlambo. Could we take just one commissioner before we adjourn for lunch? And that will be Commissioner Nwambi.
Thank you, Acting President. Afternoon, Justice Madlanga.
Good afternoon, Commissioner.
Let me also join Commissioner Dodovu to commend you for your achievement.
Thank you. Thank you, Commissioner.
But also as somebody that was once a commissioner that used to interview people in the past, I think you are too modest about your achievement, and don't be apologetic. We are marketing yourself. You know very well that you are spoiled for a choice. We have the creme de la creme of jurists in South Africa for the entire week. So don't be apologetic in dealing with the 18 that will be coming after myself.
Thank
So
you,
my-
Commissioner. Thank you.
My first question, it's as we know that this is a leadership position.
Yeah.
We're talking about somebody that will be in charge of judiciary, not only judiciary, but also this very same body that is interviewing you, somebody that will be chairing the JSC. If you can share with us your understanding of immediate challenges facing judiciary in South Africa that need some special immediate attention.
I would say it's what Commissioner, the main one of the main, what Commissioner Singh touched on. And I think also when we came back after tea, as the acting president was beginning to say he's going to call upon commissioners to come in with their questions, I said I just want to add something, and that something was something that Commissioner Singh touched on, which is the question of delays. And there's the hackneyed but useful phrase that says justice delayed is justice denied. That is an issue that every judge, every judicial office, everybody who is associated with the law, and even ordinary observers, that's something that is quite a problem that needs urgent attention. Yeah.
Thank you, Justice Madlanga. The second one, it's maybe if you can make some of us to understand your view about the value of a dissenting judgment.
There's a saying in legal circles that a dissenting judgment of today may become a majority judgment of tomorrow. Let me very uncomfortably say this. You'll recall that I said that on 31 December 2021, I delivered a judgment. In that judgment, I quote copiously from dissenting judgments by Justice Mohoro, Justice Yvonne Mohoro, Justice Kate O'Regan, and Justice Albie Sachs. Those were dissenting judgments, but it is those judgments that I agree with, quote copiously from, and I reach the same outcome that they said. Were we not in the minority, were we not a dissenting voice, this is the outcome we would have reached. And in my judgment, I reached the same outcome that was reached by a dissenting judgment. So, short point, there is value in dissenting judgments, but an important rider, we should never dissent for the sake of it. You write a dissent because you just simply cannot agree what the majority says. But my own belief, there is something that we call a hays besoek at the Constitutional Court, which for those who do not, I don't know Afrikaans myself, but I will know the odd term here and there. We call it hays besoek. So when we were still operating from the court, where you have a disagreement with a colleague, you just get up, go to that colleague's office, and you discuss back and forth your views, the colleagues' views, and see if you cannot reach common ground. And my experience is that on quite a number of times, you are able to find common grounds. So those instances where there will be dissents, I believe it is on those occasions where colleagues cannot find each other. And for the reasons I gave, there is value in those dissents.
Thanks, Justice Madlanga. My last question, it's the issue of quorum at the Constitutional Court. You know that we will have our own sessions where we'll be doing the deliberations. We normally say in the absence of information, sometimes perceptions become a reality. So I don't want to have my own understanding of it when you said if you can be appointed, you can be able to assist because it has led to an injustice in the past.
Yes.
Why will you wait for an appointment to be a Chief Justice while there's an injustice that is happening?
As they say, when somebody does not have an answer to a question, good question. Perhaps let me say, appointed or not appointed, it is. You are quite right. It is an issue that we must address. Minister, as the person that I understand would move a bill on this sort of subject, you have heard the problem, and perhaps let us take this as a formal tabling. I'm not a parliamentarian, but I will use the language and say, let us take it as a formal tabling of the issue before you, for you to please do something about it. And the other commissioners are also here, and I hope this is something they can support.
Thanks, Justice Madlanga. Thank you, Acting President.
Thank you very much, Commissioner.
Thank you, Commissioner Nyambi. Justice Madlanga, perhaps just as a follow-up, the provision of the Constitution says a matter before the Constitution must be heard by at least 8 judges. And the problem that you alluded to earlier on, in my view, could be resolved by simply adopting a rule of practice. It's 9 or 11.
With regard to above 8, if you remember, I separated my response to those situations where, as you say, we internally could find a practical way of resolving it. And I said maybe an amendment may not even be necessary, or it could be done, just as a matter of extreme caution, perhaps, to just have it stipulated statutorily somewhere. I even said it does not have to be a constitutional amendment. But the Constitution stipulates this for a reason. It has said 8. Do we, as the judges of the Constitutional Court, have the right to say, we are now 8, we cannot sit, come after a year or after whatever, when we will be able to sit more than 8? Something does need to be done with the 8. We cannot just continue, or on a continuous basis, continue operating at the level of a practical situation when there is this constitutional provision. I think something does need to be done about it. But otherwise, as I say, I do accept the idea of a practical resolution, or or dealing with it practically.
Thank you, Justice Madlanga. I do accept that an amendment would be necessary, because you might have a litigant who is difficult to insist that if there is 8 judges, then they must hear the matter.
Yes.
Thank you.
And especially say for example, the litigant who Yes. The litigant who would gain from that if the judgment of the court appealed against will stand if there's an even split. That litigant could easily say, no, the Constitution says, so please go ahead, don't tell me about postponing to some other date.
Thank you, Justice Madlanga.
Thank you.
JP Tlalete has a follow-up question on the same topic.
Thank you.
Yeah, just a follow-up on this question. I think every judge of the Constitutional Court has got the right to sit in a matter. And now if you decide amongst yourself, who are you going to exclude? And what impact will it have? I mean, that will be saying, if Judge so-and-so was in that matter, then I lost my case. Thank you.
Those are other. Thank you very much for that. Those are other considerations as well. Well, I may not have articulated as well as you do now, Judge President, but I did earlier say there will be the issue of who do you knock out and on what basis, you know. But I think you articulate it even better. Yeah. Thank you, Judge President.
Chair, may I please have a follow-up on this?
Please do, Professor Schlemmer.
Good afternoon, Justice.
Good afternoon, Professor.
Good to see you again.
Thank you very much. I'm happy to see you too.
The question that I have in this regard is, do you think there's still, or the reason initially why the minimum of 8 judges was put into the Constitution exists anymore? And the reason why I'm asking this is initially when the Constitution was drafted, the Constitutional Court as a new court was established to create constitutional law. Now the Constitutional Court has open jurisdiction, so anyone can bring an appeal to the Constitutional Court. Does that reason of having such a big bench exist since you are not dealing with the development of new law in the sense of initially with the Constitution and constitutional precedents, which we now have, but we also have that you are dealing with a lot of appeals from the Supreme Court of Appeal, which also causes me to ask, why suddenly are people not happy with the judgments that come from the Supreme Court of Appeal, and on what basis? I would like to hear your view on this.
On the, I don't think it's a. Let me start with the last part. I don't think it's more people being unhappy, you know, more than they otherwise were. People will always take an avenue that they see. Now that they can appeal against judgments of the Supreme Court of Appeal, they will take advantage of that. And then with regard to the earlier part of your question, for as long as how should I put it? For a court of 11, or let me say, I think there is value. There is value in an apex court speaking with one voice, and in this sense, one voice, I do not mean, you know, in an individual case, judgments being unanimous. No, one voice in the sense that there is a majority judgment in that case, majority judgment in that one, and so on. So there is value in that sense, you know, that one voice in that sense. Yes, I know there is another criticism that we sometimes ignore or don't take into account our own precedent and so on. But all things being equal, what should ordinarily happen is, if you sit and bank, or all 11 of us, or at least 8, we have that precedent which, if all things are equal, we should follow all the way through. Unlike if we sit in panels, yes, I know as a lawyer, you will immediately say, in particular as an academic commissioner, you will immediately say, but no. You should be aware that panel A there decided another case this way, and panel X there decided another one that way. But the problem with that is, if that panel decided that way, as much as we should all be disciplined only to depart from earlier judgments if they are, what's the term we use, clearly wrong, even though there is that, you know, but there is that fundamental thing that human beings being what they are, that I was not part of that panel, and I think they decided that case wrongly. It may be easier for another panel to say that that was clearly wrong. Let me give you a case in point. Justice Mhlantla, when she was still at the Supreme Court of Appeal, she decided a case, or rather wrote for the majority, deciding that way. Exactly a year later, same date, a year later, a different panel, of which she was not a part, decided another case on the same point completely differently. And I think that was exactly a function of the fact that the Supreme Court of Appeal sits in panels. I doubt that within a year, if they sat and bank as the Constitutional Court does, they would have kicked away their own judgment within a year. I doubt it. So there is that value in sitting and bank. But I understand the point that if we sat in panels, we would go through our work much, much quicker. I understand that. Yes.
Thank you, Professor Slema. At this stage, we'll take the lunch adjournment. According to our schedule, it was supposed to be 1 hour long. Do we still stick to that? I make it 2 o'clock, which means we would then have to resume at 3 o'clock.
I propose that we come back at 3:15. So it's me, it's Madonsela.
Yes, I've noted you, Commissioner Madonsela. I'm just looking around to see if there's any dissenting voice, and it doesn't appear.
I don't agree with that. You know, we hold very different and difficult responsibilities. And when you call us to come and spend a week here, we do so, but during lunchtime, we try and satisfy other responsibilities that we hold somewhere. So when you allocate an hour, we also put appointments in that hour so that we don't lose time. So I think that we have adopted the program as is so that we are able to perform certain duties in between executing these other important responsibilities. So I say...
I take your point, yes. Commissioner Malema. You need not say more. We'll adjourn at this stage and resume at 2 o'clock. Thank you.